which will cost you and other ratepayers many millions of dollars, which are possibly actions that he was never authorized to take. Against this backdrop, I urge this commission to take a very careful look at the implications of the city of Gainesville buying this biomass plant out in order to get out of this possibly illegal contract. The purchase of the biomass plant, according to GRU's figures, based on an assessment of $450 million, and the reason I'm asking you to look at that bottom line, the $450 million, is when they duped a majority of the city commission into even making an offer, they used the $450 million figure to come up with the $10 million savings by getting out from under the ad valorem taxes on the plant, which represents practically half the savings in this bogus analysis they did. And getting back to the slide, should Mr. Crapo do his job, and I have no reason to believe he won't, and assess the plant at $450 million, if the city buys the plant, you lose $3.9 million annually. The school board loses $3.7 million annually. GRU showed lower figures, but for all their calculations, they used the high figure with the $10.6 million ad valorem tax bill. We sent our communication director / lobbyist to Tallahassee in a county car. He doesn't have suitcases full of cash for campaign contributions. He doesn't have a governor's club membership. He doesn't have the other tools of the trade. It's a family show. I won't go into those. But why don't we send him across the street and explain to the city commission that this purchase is not in the best interest of the Alachua County Commission or the school board, that dodging the ad valorem taxes on the plant are not savings. GRU looks at them like savings, but they are not savings, because you're stuck with dealing with the negative implications of this plant while the revenue side of it is gutted. Now, there's other issues here. If they ram it through the fuel adjustment charge, you don't get to tax anything. If they would put the contract through the base rates, you would be able to tax it. They're free to put it through the base rates. It's a custom to pass it through the fuel adjustment. It's not a legal requirement. There's many different ways that this can be dealt with, where the revenue fallout from this monstrosity would be fair to all concerned governmental entities. But to sit here idly and slash your budget to and into the bone and not pay attention to the revenues going out the back door under highly questionable circumstances is unsustainable financially. These are real revenues. Hunzinger stood here for hours. You debated for an hour and a half whether citizens would even have an opportunity to respond. You weren't going like this when Hunzinger was feeding you a bunch of BS, basically. So in these analysis, and right here, which is just a totally bogus analysis, there's no mention of the $32 million fuel overcharge. It just vanishes. It just goes away. $32 million. A big chunk of that, it came out of your hide. You represent 30% of GRU's ratepayers. The only local government looking after them, 30% of 93,000 customers. So I just don't see any way why you could, and even other people on the city commission have my concerns, that these are not savings by getting it off the tax rolls. So I just don't see why we don't send Mr. Sexton, who's an icon in our community. All you guys are savvy in the business and nonprofit world. You're not just, policy wonks like across the street. You can understand the implications of these numbers. Send Mr. Sexton over there, take a position, and be at the table when this thing goes down. It's not in anyone's best interest for this plant to be bought, certainly not at the $620 million purchase price GRU is pushing, which is $200 million above what they predict Mr. Crapo is going to appraise it at. And these are...
You could please bring your comments to a close.
I'm done. Thanks.
Thank you. Who'd like to speak next? Good morning.
Good morning, Mr. Chair, Debbie Martinez, Commissioners. As Mr. Connors just stated, the deal the majority of the City Commissioners approved last Thursday with GREC, the out-of-state company who owns the biomass incinerator, will cost the county $4 million in lost revenues, and the school board will lose $3.7 million annually. GRU customers living outside the city limits will have to pay an additional 25% surtax on top of these costs. Too much risk, $450 million more debt piled on top of GRU's current debt of $1 billion, much of which was accumulated under GRU manager Bob Hunzinger's watch. All this risk in hopes that just maybe a few dollars might be saved on our sky-high GRU bills, resulting from the 30-year overpriced GREC contract for power that we did not need and do not need. Certainly these commissioners are not piling on all this unneeded debt, operational risk, design risk, pollution risk, and others just to bail out Jim Gordon's incinerator project. It is not the job of commissioners to help Jim Gordon flip his plant. For the past 5 years, GRU management kept telling us that it is far too risky to own the incinerator, and now all these risks have magically become benefits. Now the people are losing trust not only in GRU management but city commissioners. This is not some little mistake that nobody saw coming. GREC hired attorneys who specialize in white-collar crime. Mr. Hunzinger was unemployed when Begin Hanrahan invited him to Gainesville, paying him approximately 60% more than what he earned at his previous job to come manage our utility and negotiate a biomass incinerator contract for power that we did not need and still do not need. On May 7, 2009, Begin Hanrahan encouraged the entire commission to approve the largest and worst contract in our city's history, a 30-year contract obligating GRU customers to pay more than twice the market rate for electricity. This is a disaster of their own making. For years, citizens warned them, asking them to exit the contract when it would have cost less than $2 million to do so, and they failed to listen. The city has spent tens of millions of dollars on attorneys and consultants trying to stay in a bad contract for a biomass incinerator that is fraught with problems. And I will not go into the problems because I do understand that there will be an item on the agenda to discuss some of these problems. Turkey Creek residents have good reason not to trust GREC. GREC CEO Jim Gordon won the bid to build what has become the GREC disaster by allowing GRU management to falsely claim that Gordon's company has built and was operating 5 biomass plants. In fact, Gordon had only built 1 biomass incinerator plant, 15% the size of GREC. It was mothballed for 14 years after Gordon flipped it. Even if Mr. Gordon puts a gold-plated silencer on this incinerator, damage will occur. This commission is the last lifeguard on duty. The people of Alachua County are depending on you to protect us, and thank you for your kind attention.
Thank you for being with us. Who'd like to speak next? Morning.
Good morning, Commissioners. My name is Paula Stamer. I'm an interested citizen and concerned about the GREC project. I also had been an intervener before the Public Service Commission when GREC and GRU filed their joint need petition for certification. I just want to speak briefly, following up on the remarks of Ms. Martinez, and saying that for whatever reasons, there's been an identification of interest between the city and GREC. I'm sure that people had good motivations, good ideas in the beginning, but because of this identification of interest between the two, the city never found the distance it needed to really objectively view the project as it progressed or as the contract was changed in protection of the public interest. you have that opportunity in a number of ways, and I realize one of the issues is going to be discussed later on the agenda. And so I ask you to take this matter really seriously. The city seems to have found itself in a bind. There was progress last week, given that the gist of the discussion before the City Commission was not cheerleaders for the biomass and us opponents, but rather the Commission saying, well, this is a bad deal, how do we make the best of it? And that's better than saying, oh, why are you upset still? It's really a wonderful thing. But I think, given how much they're personally invested in this project over the years, how much they have supported it, it's very difficult for them to get the requisite objectivity in analyzing the actions they take with regard to the GREC project. I think you have that capacity. You're not as invested. I know that some of your friends and colleagues have been engaged in promoting GREC. And I ask you to put those affiliations at a distance and really consider the fact that the public has not had a real opportunity to voice its concerns from the very beginning. The public was very much marginalized in any discussions as the contract evolved. Only recently have we had a chance to speak frequently before the City Commission to address the substantive issues. But as a consequence, we've had several years of compounding one problem after another because people weren't able to objectively stand back and say, you know, perhaps this isn't a good idea and perhaps there are a lot of flaws. So I hope you will take this matter seriously and recognize that it's not a matter of pitching yourselves against your colleagues across the street. It's really a matter of protecting the entire community, their health, their welfare, the air quality, the water quality, the expenses, which are going to be horrific. Anything you can do to help mitigate those problems will be greatly welcome. And I think they really do fall within the purview of your authority and responsibilities. Thank you.
Okay. Thanks for your comments. Good morning.
Good morning, sir. Mike McEachin. Mr. Chairman and Commissioners, I trust you to do the right thing. There were 21 members of the public got up and spoke over the City Commission the other night, and every one of them told them don't buy the plant. They did anyway. The Gainesville Sun, in today's editorial, tells them don't buy the plant. I hope that you will, and I'm sure you will, continue to do what it looks like is on your plate to do. I would like to cover another subject. I asked to be on your agenda, but your staff said that I would have to do it at public comment period time. I wanted to call your attention to something. Oh, by the way, I left some papers over here for your clerk to pass out to you. I apologize for the pictures because paying GRU rates, I can't afford to buy another bottle of color ink. And I couldn't make enough copies for each one of you, so maybe you can pass them around or have your staff make copies for you. Most electric generation requires incineration of something. And other sources like solar and wind require storage at times when the wind's not blowing and the sun's not shining. Now there's a new technology. Really, it's not a new technology. It was developed in the space industry. It's a chemical reaction which does not require incineration. The technology is beginning to make headways. A company called Bloom Boxes, and I'm not a salesman nor do I advocate this particular company. How Save and some other people have researched this subject and found several other companies that are doing the same thing, although I believe Bloom Boxes are out in the front of the rest of them. They are powered about 30 large customers and is developing smaller units for residential use. Mr. Chairman, this might be of interest to you since I understand you were off the grid or would like to be off the grid. And this, from what I can read about it, is very dependable in the 99.99% category. 4 nines is hard to reach. The companies, the big companies include Coca-Cola, AT&T, and I think the papers that I left up there have articles about Coca-Cola and AT&T and some of the other large companies that are using these boom box type of generators. If this, I think we're on the verge of finding relief from our high costs of burning things to generate power. I spent about 15 minutes on this at the airport authority when I presented it to them. I hope that you'll have some questions about this, and I hope that you will get your staff to look into the industry about these individual type generators that we will have. Because if you look, technology changes things. 20, 30 years ago, before the vestiture of for the breakup of Bell system, you were paying 30, 40 cents a minute for telephone calls. Now, if you're paying 3%, you're getting ripped off. In many cases, you can get the long distance calls for free as a loss leader sort of thing. So that's an example of what can happen with technology, and I hope that you will be curious enough to look further into this, and if I can answer any questions, I would be happy to.
Looking it up while you were speaking. Thank you. Appreciate you being with us this morning. Would anyone else like to speak during citizen comment period? If not, we're going to close out the first of our 4 citizen comment periods, and
Good afternoon, Commissioners. My name is Paula Stamer. I only briefly want to state that I'm generally in support of anything that's going to strengthen the state and local government's ability to protect our land and our water resources. I appreciate Commissioner Barrett's comments, but I think the overall objective of conservation is in the public interest, particularly with regard to our water supplies, which are increasingly endangered and diminishing. As you all know, I've been a steadfast opponent of the GREC project, and one of the reasons I've been an opponent is our free giveaway of over 1 million gallons of water daily for an unnecessary facility. And it seems to me that that action conflicts with what has been the express policy for this county and for the city of Gainesville, as well as the state, to be protective of our water supplies. So to the extent that this resolution could help further support and bolster state support for conservation, I'm in favor of it. Thank you.
okay, thank you for being here.
Mr. Chairman, may I say one other thing?
Sure.
The one component of the amendment as it's going forward was the fact that it will go for certain water restoration projects, which as we go forward, I think is going to be more significant. And having been, involved with some of the water groups, as we look forward, that's going to be, obviously water is going to be a huge issue going forward, and to have a funding source for it, I think will probably be a good thing, so that we don't have to, worry about how we're going to fund some of these projects, because that's going to be a part of the conversation as we go forward. And this gives a dedicated funding source to some of the water restoration projects as we go forward.
Yeah, thank you. Was there any? I'm sorry.
Debbie Martinez, just quick, if you're concerned that if this initiative could possibly affect people who are struggling to purchase a home, just remember we have a new homeless shelter opening up soon. Thank you.
And for the record, it won't affect the price of your home. It's existing staff. We're not looking to
Good morning,
increase it.
sir. Ernesto Martinez. I would just briefly like to speak in support of the comments made by Ms. Susan Baird. Thank you.
Okay. Would anyone else like to speak?
Morning, Mr. Chairman, Commissioners. Nathan Scott. Just want to speak in support of preserving Florida's natural resources and conservation. Again, our springs are at risk, our aquifers at risk, and so taking steps on a statewide basis is certainly worthy of furtherance of protecting this very valuable resource to the state of Florida. And with respect to home locally, I just wish the same attention would be given to fixing our fiscal problems in terms of some of the challenges facing GRU customers. Thank you.
Thank you. Welcome.
My name is Harold Save in support of the action, and I was surprised to learn last night that we are hooked up officially to recycled water to the GRU plant, but they are not yet using it for some reason. Maybe they don't want to pay for it. We don't know why. But I was there when the certification was done and talked to everyone involved. For some reason, the water hasn't been turned on yet. They're still pumping it out of the aquifer.
Okay. Thank you. Would anyone else like to speak? The motion on the floor. Back to the board then. All in favor, please say aye. Aye. All opposed?
No.
Passes 4-1 with Commissioner Baird in dissent. Mr. Clerk, let's move to the other item that I know we have people from the public here for, the GREC item.
That would be the added item to the agenda. It's the Gainesville Renewable Energy Center LLC GREC air permit.
Bird.
Good afternoon, Mr. Chair. Chris Bird, Environmental Protection Department. I do not have a presentation, a PowerPoint. As you know, this really came up since your last meeting 2 weeks ago. The board passed a 4-part motion to try to address some of the concerns that have been coming up with noise, dust, odors, and some of the other air quality concerns that we've heard from. And since then, there was an ad in the newspaper by the Florida Department of Environmental Protection where they're proposing to modify a construction permit for the Gainesville Renewable Energy Center, the biomass plant. I think in discussing this with the county attorney's office, we believe that there's an opportunity with this permit modification. There's an opportunity. I'm not saying it's a guarantee, but there's an opportunity to try to address some of the concerns that we've been hearing about and what staff has also been able to confirm. I guess I did want to kind of explain what, if you go with the recommendation, which is for the county to petition for an administrative hearing, I do think it's important for you to understand what we're getting ourselves into. And I know on the agenda item, I tried to list some of the issues, so I wanted to walk through those if that's okay. The first, and the county attorneys can elaborate, but the administrative hearing process, and this is governed by Florida statute. It's a procedure. It's a rigorous process. So, you know, if we're going to do this, we need to understand that it's something that is going to require significant preparation. But we've done these things before. We don't do them often, and they can also be expensive depending on which way they go. I think. And I can get into this later, I believe that the issue that we probably have the most chance of dealing with through this petition process at this point is the dust issue. And I know that there's concerns about noise, there's concerns about haze in the sky, there's concerns about odors. Odors may be something that we could look at, but I don't, other people can maybe explain this otherwise, but I don't know about the noise. I know that's been what a lot of people are concerned with. And the reason I'm saying that is that the permit, the Florida Department of Environmental Protection permit, all it really says about noise is that you have to comply with the local codes. There's no state rules on noise. And so I just wanted to put that right out there in terms of where we're going, and we're asking you to approve a motion here. My position is that probably dust and maybe the the odor, those are the ones, at least with the time we've had to look at this, and you got to understand, we just got this last week to start looking at. From what we know right now, that's probably the areas that we have the best chance of getting something done. Understand also, depending on where we try to go with this, we will have to hire outside technical expertise, because a lot of this goes into, you have to have expert witnesses and you have to prepare. So again, in terms of what we choose or what you choose to do with this, depending on the issues that you include in there, is the cost of this in terms of outside assistance is going to go up. You're aware, and I think when we talked about this 2 weeks ago, GREC, they have explained that they're doing some things to try to deal with the dust and to try to deal with the noise and the odor issues. We actually had a call with them yesterday afternoon where they did give us an update on some of the things they're doing. The challenge we have is the deadline, the filing deadline, if you choose to go forward with a petition for administrative hearing, is I think it's October 28th, which is next Monday, maybe. So it's coming up really quick. The indications we've received from GREC in terms of improvements they're making, they're not going to be done by next week. So that's kind of the dilemma we have. Is that, I mean, I think we would all like to see them address the issues. We're not going to really know if they work until after this deadline, the filing deadline, which is next Monday. And the other issue that I'll bring up, and this is just where we are now, you've heard complaints from citizens, you've heard the Public Works Director show you what they've been dealing with out at Public Works in terms of this wood debris falling on vehicles and employees complaining about respiratory issues. We've had the Florida Department of Environmental Protection, they've been out there at least twice, maybe more. The days that they went out there, they reported back to us that they didn't see a problem. So where we are right now is that it could have to do with the way the wind was blowing the day they were out there. You need to understand that this is the noise may be different, but the dust issue in terms of whether it's affecting Public Works has everything to do with which way the wind's blowing. I mean, if it's blowing the other way, that day they're not going to have an impact. So I think I wanted to make you understand in terms of the county having a case to try to get some things done about dust. Our challenge is we're going to have to develop some new evidence that we don't have currently. I mean, we do have some. We have some photographs, and we do have. And since really your last meeting, Public Works is doing a really good job of trying on a daily basis. They are documenting what they're seeing falling on the ground. But I will say, I will report back to you just before you're going to make this decision that the last 2 weeks have actually, my understanding, they've been much better out at Public Works. And I'm not trying to suggest that means the problem's solved, but the last couple of weeks have actually been better, which is good news, because I think, that's the outcome we want. We don't want them to have problems. So with that, I'd be glad to try to answer any questions, and I'm sure the Attorney's Office has some of the answers that I won't have.
Thank you, Ms. Byrd. Commissioner Baird.
I think one of the major challenges we have is this time constraint for the issuance of, I believe, the CO, and some of their permits that they're expecting, I think, in a week or so. And if we have enough information based on what we're actually looking at to make sure that they are complying with what they said they were going to do, or what is actually legal and not legal, because what they said they're going to do and what's legal might be two different things. Because I guess my concern here is the particulates, meaning that the source of small particulates of 2.5 microns or smaller, to 10 tons per year. And the GREC's permit application indicated that the GREC plant would be emitting an estimated 278.3 tons of 2.3 whatevers per year, and that's nearly 30 times greater than the EPA's maximum. So that's a concern that, we have more particulates than what I guess we would consider that they want to have, when the EPA has said that they shouldn't have more, that's 30 times more than what the maximum is technically allowed based on the EPA's assessment of what is acceptable and not acceptable. So I guess my question is, which standard do we use? Do we use GREC's permitting application amount, or do we use EPA's maximum allowed? And is there anything that's going to determine which one is the benchmark that would be appropriate to determine whether the permit should be allowed or not? So there's a lot of things that my main concern, and are they not using their masks anymore over at Public Works? And if they don't have to, I guess that's a great indication. But at what point do you say, well, if the wind is blowing the wrong way, or how long of a period of determination do you have? Is it a season? Is it 2 seasons? Is it, I don't know how wind shifts and how all that works either. So we make sure that we're not going to go ahead and give approval of something that is going to end up being a problem in the future. Because unless we have some type of recourse, and I think somebody had mentioned the possibility of a 1-year recourse of compliance for the plant. So I don't know if we can add that into the variables as to what we need to make sure that we have a good understanding, because EPA probably has a standard for a particular reason. And if it's 30 times that level, is that acceptable or not, and who do we determine that? Do we go ahead and add that to the list of items that we want to make sure that either our consultant helps us with, or we determine and have a recommendation on that?
Mr. Chair, Commissioner Baird's bringing up there's an issue that has to do with a federal standard on fine particulates. This is the really small, less than 2.5 microns.
Right. They all received an email
Yeah.
of this information. I don't know whether they've read it or not.
We spoke to, or staff spoke to, the Florida Department of Environmental Protection, the air permitting people this morning, and it's my understanding, and I think they had already, back in 2010 when this came up, the state responded back to EPA, and really this is a conversation between the state and the federal government. The state is claiming that some of the other controls that they've included in the construction permit are going to address the compliance issue with the fine particulate, the 2.5. My understanding is right now they're operating under this construction permit, and that's a permit from the Florida Department of Environmental Protection. That doesn't even expire until December of next year, 2014. What they will be applying for is their final operating permit, which I won't use the acronyms, but it's called a Title V permit. This is a Federal Clean Air Act permit it's really authorized by the U.S. EPA. The process is kind of delegated through the state of Florida. My understanding is that, well, first of all, the petition requests that we're talking about today has to do with the Florida Department of Environmental Protection construction permit, because the notice in the paper had to do with modifying this construction permit, which actually doesn't expire as it's written now. It doesn't expire until December 2014. The part that I guess we can try to look into, but you need to understand, we don't have a lot of time between now and Monday to really bring this in for a landing, is whether that issue, whether it's appropriate to try to tackle that issue right now with this state construction permit. The issue is that PM 2.5 is covered and it's regulated by that final Title V permit. And so I think we're still trying to sort that out. Again, at this point, my gut is that we need to try to focus more on the dust. And keep in mind that the dust does include some fine particulates, so there may be a relationship there that we can get in. But I'm trying to be cautious with this, because if we try to if we try to do too much in this petition, it blows up really quick. And I really think we've got to choose our battles. I'm not telling you we shouldn't do that, but I don't feel comfortable telling you we should with what I know right now. Should try to deal with the 2.5 in this permit. But we can certainly look at it. We may rule it out as just something that's really not ripe for this part, or this part of the process.
Who has the floor? I'm sorry.
Susan.
Oh, I was in. I just wanted to make sure because that this is brought up because the American Heart Association and the Florida Medical Society have campaigned for the banning or tighter regulation of biomass plants to ensure that those 2.5 limits are strictly adhered to. And right now, the permit that they're requesting is 30 times greater than the EPA maximum. So that is a concern. Those are two big associations, not just our neighborhood watch group that has decided that this is a bad thing. It's very, very big associations that have done a lot of research.
Mr. Attorney, is this an old light, or do you want to speak?
No, it's a new light.
Okay, go ahead.
This is the first I've heard about 2.5 particulate matter. I think it's the first Mr. Schwartz has heard about it. So here's the situation we're in. We got till the 28th, that's next Monday, to file a petition. We can't sign a petition that we don't think we have evidence to prove. We were concerned, based on the Public Works compound and other surrounding property owners, and have received complaints about large particle fugitive dust. We're concerned that if the air construction permit is amended, that's what we're talking about, is the first permit that FDEP issues for this type of a facility. It's called an air construction permit. If it's amended, we may lose our opportunity to influence the plan that the operator has to implement to control fugitive dust particles. That's what the complaint's been about. We don't know right now how much this is going to cost us to handle this litigation. We've got an estimate from the environmental protection staff that a consultant will cost around $80,000. Our plan is to handle an in-house attorney until the limited in-house staff we have is no longer able to handle it based on a capacity issue. We have the expertise to handle it. It's an opportunity to get our foot in the door to try to influence what's going on at the plant with a view towards minimizing the impact as it relates to dust primarily on county property and surrounding property owners. And so that's the reason we're here today. It's a step to try to have some a place at the table and some leverage. It's really the board's call whether or not you do it, but it's limited at this point in time. I don't think we're going to be able to develop the evidence between now and next Monday, or any idea of a theory that's going to be viable as it relates to some of the other air emissions. It's just too late for us to do that. That doesn't mean we won't have a chance to look at those at the last permit, the air operation permit. But we're not, I think we ought to, I agree with Mr. Baird, we ought to focus our energy on what we got the complaints about at this point in time and try to move to fix them.
Thank you. Commissioner Hutchinson.
Well, that was, the question I wrote down was, are we dealing with just the visible dust or the invisible particulates from the stack? And we dealt with a lot of this PM 2.5 business a decade or so ago, and it becomes very expensive to get the evidence. So I would move that we authorize Alachua County to petition FDEP for an administrative hearing regarding their intent to issue an air permit to Gainesville Renewable Energy LLC, and that we tell our staff that we primarily want them to focus on the fugitive dust issues.
Is there a second to that, the whole thing?
I'll second it for the discussion.
Second for discussion, that is staff's recommendation with the addition of the final sentence. That concludes your comments, Commissioner Hutchinson.
Yeah.
Commissioner Pingeson.
Chris, I think this is probably actually, Mr. Chair, this is going to go to the attorney. What about the noise, and what about the odors? We've had complaints, and I guess that's something that could be considered subjective. We've gotten plenty of emails about the fact that noise ordinance for the city of Gainesville is more expansive than just having a decimal meter to tell you how, what the decibel readings are. So how do you go about collecting evidence, or is that not going to be part of the conversation, which is the part of the motion that maybe we need to discuss?
Yeah. Well, we both agree that where we are now, I was going to say the same thing, based on the scope of the changes to the air construction permit, which is what this is not going to, they're not trying to change what their current permit says they have to do as it relates to noise.
Okay, so is this something that when they apply for, is that going to be included in the administrative hearing at all? That the
noise is not in this air construction permit. They're not amending anything in the current air construction permit as it relates to noise. So we're not going to be able to influence that. Here's the bottom line on noise. Okay, first off, the governments that have noise ordinances need to look at their noise ordinances from the standpoint, is there a way, and we've got Mr. Wolf in the crowd, he and I have talked about this, is there a way to regulate through an objective standard low-frequency noise through an objective measuring technique? That's what this is. That's what the noise is about. It's about low-frequency noise. Everybody agrees that the noise that's coming from the biomass plant is not tripping the traditional type of decimal standards we have in noise ordinances throughout the state of Florida. You gave us an assignment to start, for the county noise ordinance, to start looking at the noise ordinance. I think what we're going to have to do is, in addition to Mr. Wolf's help, he has some expertise in this area. We're going to have to probably look at other ordinances and possibly get a noise consultant involved as it relates to what we can do, because this is not, to my knowledge, common in the state of Florida that counties and cities adopt noise ordinances that actually look at low-frequency noise. This has been a recurring problem. Just because it's low frequency doesn't mean it doesn't adversely affect people. Okay, so the second thing is, and I've said this to staff so they know I'm going to say this, we got to look at who's enforcing the noise ordinance. We got to have a discussion with the sheriff. Does the sheriff want to enforce the noise ordinance, or should the county take over enforcement of the noise ordinance? Because other than intermittent noise, barking dogs, that kind of thing, it seems to me like every time we get a controversy like this on the noise ordinance that gets to this stage, it comes in front of the county commission or maybe the city commission. I don't really watch what's going on now in the city. So the threshold question is: if we're going to have noise standards, we're going to develop new noise standards, what mechanism are we going to have to enforce them? This may be a resource issue with the law enforcement community. It may be that there are instances where we need law enforcement with us to enforce it if we take it over. But actually, in my opinion, the enforcement of the noise ordinance is for probably very good reasons, not working very well here. We saw that it's so hard to do when you have the noise meters. You have to keep them calibrated. You have to be there to measure them, and there's a lot of high priorities for our law enforcement community to deal with that are not of the type of that noise really is not going to ever be, I think, in the law enforcement community, the number one law enforcement priority. It just won't. There's too many other things. So I think that's a second issue we have to address. But first and foremost, once we figure out who's going to enforce it, they need to be with us when we develop this noise ordinance, because it's whoever's going to implement it's got to have ownership of the standards. And then we need to develop the noise ordinance, because I think for any action to be viable to try to minimize the impact of the biomass plant on the citizens, it's got to have an ordinance basis. we got to start with that point, because there's several legal theories that will permit us from jumping right into circuit court to try to deal with this issue. And so there's a lot to be done in noise, but we've had the same noise ordinance with some minor modifications for 20 years, so it's time we take a look at it. And
so I guess, Mr. Chair, my question is, if we don't focus in on noise and odor with this particular action, we don't lose the ability to do so down the road?
That's correct.
Okay.
Yeah, actually, I just don't. I just don't see. I see Florida Department of Environmental Protection with their air quality program very concerned about air emissions from this plant. They're going to pass, the whole noise issue has been passed to local governments throughout the United States. It started at the feds, it went to the state, and it's been passed to all the counties and cities and towns and townships throughout the United States. We got to deal with that one, and I don't think we're going to be able to deal with it effectively through the air construction or air operation permit. It's going to come down to what our local government ordinances say.
But there's a couple more permitting process. If it continues to be a concern, if the mitigation that they're currently attempting doesn't take care of the problem, where do we intervene, or what can we do in a situation like that to raise our concerns?
The first step is who's going to enforce the noise ordinance. The second step is what modifications are we going to make to the noise ordinance to try to address these low-frequency sounds. The third step is, do we have scientific basis for that second step? So we're going to have somebody that's going to be able to provide the objective scientific basis, because it hasn't, to my knowledge, it hasn't been done, but we really haven't started digging into this. So we're not going to be able to do anything until we have a noise ordinance. Complicating the situation here is our jurisdiction of our noise ordinance is only in the unincorporated area, basically. There is some language about if there's a noise that you can hear in the unincorporated area, but the sources of noise is in an unincorporated area, we can enforce that.
Can or can't?
We can. Right.
Well,
but you got to have what we don't know now is the measurement issue. We don't have that because everybody agrees. Mr. Wolf's been out there. By the way, he carries a noise meter around with him. And he's used his noise meter. The police department for the city of Gainesville, and I think the sheriff's office has also measured noise at different spots around there. And it's just not, we've had this situation before with noise. A lot of times you go any distance away from it and it's low frequency, it doesn't trip those meters.
Well, other than the fact that we've determined that Mr. Wolf is just Mr. Cool with his decimeter or whatever, okay, what I'm hearing is it doesn't sound like you can make the case that, we're having complaints. It doesn't trip the standard for level of noise, but it's obviously irritating a lot of people. What are you going to do to mitigate it? What recourse? Because that's in a nutshell, that's what's happening.
You're exactly right, and I think what we do is we first off we look at our noise ordinance and figure out whether or not we have the ability to move to an objective measurement, a technique for low-frequency noise. That's number one. I think that's possible. I don't know. I think that'll probably involve a consultant helping with our staff and Rick Wolf. Before we even go there, we need that threshold determination, because we don't want to go off and adopt a noise ordinance and then thrust it upon, let's say, the sheriff, without the sheriff having ownership of what we're going to do. If the sheriff's going to continue to enforce it, they got to be at this table. Then the next thing we do is, to the extent we have this expert on board, because there are some things that GREC may be able to do with the plant to minimize the impact from a noise standpoint. There are things that have already been identified that they can do to minimize the impact. And that's any process that seeks enforcement will try to minimize the impact. I don't think we'll be in a situation where the noise will go away completely, but I think there's a way to reduce it. But I don't know what those modifications to the plant would be, because it's a biomass plant, and there's mechanical equipment, and there's a stack, and there's some work that's already being done to try to minimize it.
Okay, so hearing the explanation, I guess boiling it down to, from a functional standpoint, are we going to be able to get our ducks in a row and do what we need to do so that if we do have a noise ordinance and we figure out all the things that you were talking about, it won't pass the threshold that we can have a say-so in this conversation, or are we talking about something that we go through all these iterations and at that point the GREC plant, the biomass plant, gets grandfathered in because it wasn't it's operational before we figure out how we're going to address the issue. I know a lot.
You're asking me how long is it going to take to develop the noise ordinance?
Yeah, kind of, sort of.
It depends on how fast we move with setting up the meetings. We just talked, the manager and I talked with the manager's staff yesterday. I said we need to have a management attorneys meeting with the sheriff on noise, and that's going to be set up because we need to develop a plan. How long is that going to take? I don't know, but normally we're not ready just to write an ordinance right now because we don't have any scientific basis to establish those low frequency levels. In fact, I've heard that they can be established. I haven't confirmed that.
All right, and Mr. Chair, I apologize that I'm asking so many questions, but the what in my mind, it would seem that there should be city involvement with this. I mean, to me, it doesn't. I mean, these are issues. They don't own the plant yet. They have a contract with. They have a contract with the people building. It would seem to me that it would behoove them to be a joint, whatever the correct terminology is, as we go forward, because it's in their concern too that they get these issues squared away. So would it not be appropriate to send a letter to the city to say we're going for an administrative hearing? Would you like to be a partner in this as we go forward, plus have them sit down with and discuss about the noise ordinance, because there's also in all this there's been the discussion of, well, whose jurisdiction is it? It's not our jurisdiction, it's your jurisdiction, and that way we can without the city of Alachua being in there, they certainly welcome to be a part of it, because it looks like they're looking at a noise ordinance as well. That it seems to me that the city should be involved in this, because it just seems logical.
Makes sense to send them a letter and try to get them at the table on both issues. I agree.
Okay. All right. Thank you, Mr. Chair, for indulging me.
Manager Baker, did you want to add something?
Mr. Chair, regarding the issue of noise, in my absence last week, Mr. Hedrick met with the city manager of Alachua, and some GREC officials, and the police chief and a representative from the sheriff's department. And they are looking at least posting a website and addressing the various complaints that are coming in. I was trying to find that email, but I can't on a report of that meeting, but I will send that to you as soon as I can pull it up. But they are working together on the noise issue.
Would the maker of the motion ask to include that we send a letter to the city of Gainesville regarding their involvement in this administrative hearing, as well as we go forward with the noise ordinance, that they be included in the conversation?
Yeah, certainly. And I asked at our last meeting, when we knew this was coming forward, that GREC be invited every time we're discussing their business.
That's fine too. So you'll include that in the motion?
I don't know if they were, but yeah, I mean,
Bert, can you answer that question specifically?
Mr. Chair, we did, we contacted GREC last week once we knew we were trying to put this on the agenda, and we did alert them. Over the weekend, I had several conversations with some of their reps, and then yesterday we had a conference call with them where we kind of went over this. They kind of explained their interest in this modification, and so they know about the meeting today, and they knew we were going to discuss this.
Okay, but they are being formally invited whenever it's on our agenda from here on. Okay.
Let's do a different motion with respect to the noise, because this is very much about the air permit.
Okay. Commissioner Chestnut.
Thank you, Mr. Chair. I guess I have a couple of questions. I guess my first question is from the blue sheet when it says that the Florida Department of Environmental inspectors from the Jacksonville office have conducted several site inspections in response to the citizens' complaints and have not yet validated the air permit violations for fugitive dust or odors. So when will they validate that? Or is that our responsibility, and that's why you're asking us to spend the $80,000 to validate something the state is supposed to be validating? Am I misinterpreting that?
No, Mr. Chair, no, I think that's correct. All I wanted to let you know is that they've been out, and if we have this administrative hearing, the Florida Department of Environmental Protection, my understanding is their position there is that they're proposing these changes, and so they're going to defend what they propose to change, which doesn't include the issues that we're having problems with.
Which is the dust and odor?
Yeah, right. They're not
going to validate that.
Well, they're not proposing in the permit modification to do anything different on those issues, which is probably that's the main reason we've got a concern that we need to petition. All I was trying to explain is that we're going to have to build a case between now and when the administrative hearing happens, and we're going to work on that. But that is part of why we need to hire somebody to help document some of this.
Okay, I guess my next question is: the City of Gainesville aware of we're filing an administrative hearing complaint? Are they aware of that? The City of Gainesville?
I believe that Mark Sexton contacted GRU at least. I don't know if Mark's here, but I took care of contacting GREC, and I think Mark.
Mark Sexton, Communications Coordinator. Mr. Chair, I did have a conversation with Kathy V. at GRU to make her aware of this item being on the agenda today.
Okay, and I guess my question is, how is the City of Gainesville addressing these issues or these complaints? I don't quite understand. We're addressing the issues and complaints as a county, and don't they have some responsibility in this?
Mr. Chair, I mean, they are the landlord of the GREC facility, so and there's a lot of other relationships that other people in the room know more than me about. They have, especially on the noise. I mean, they certainly have some issues there. But I think the challenge has been where the residential complaints have been coming from, have been from mainly the city of Alachua.
Mr. Chair, I understand that, but I mean, that's a sly way out of it, really. When we know that there is an issue, I mean, and for them to shuck on their responsibility, and I wouldn't want to say that because I'd be making an assumption that they're doing that. So, but it appears that they're doing that, and I would just expect a little bit better response from another form of government in terms of issues of complaints, which even though it's in a different jurisdiction, this is going to lead to my next question. And my next question is, we know that the residents of Turkey Creek is in the city limits of Alachua, and they have voiced some issues and concerns. And I guess if the city of Gainesville is going to move forward with purchasing GREC, and we're filing an administrative hearing complaint, how does that play a role in getting them to correct anything if they purchase it from GREC? Do we now then look at the city of Gainesville and filing some hearing or something against them to address the issues for those citizens that's in the unincorporated area, which is, I think, is the Hague areas that we're concerned about also, but also the Turkey Creek folks? I guess, do we move forward with filing a complaint against the city of Gainesville is what I'm asking. In essence, if they purchase GREC, how do we deal with that? And are the Florida Department of Environmental Protection, are they aware of this particular purchase or potential purchase? How does that play a scheme in all of this in terms of getting our issues in terms of dust, odor, noise, and all of that addressed? I'm just concerned that people play a game sometimes. Well, we've sold that, that's under there, that's their problem, they got to deal with that. So, or the administrative hearing complaint we're filing, will that address all of that too with them purchasing it? Or I'm just concerned because I could easily see how we could get lost in this process and nothing ever get done, and they're permitted and they're running, and there's nothing we can do. And I hear the attorney talking about a noise ordinance and stuff like that, and I don't know how fast and how quick we can get the experts to do that particular noise ordinance. So I'm really concerned about this whole process because the dynamics have changed now. If the city of Gainesville is going to purchase GREC, the dynamics have basically changed. But I'm kind of disappointed that they did not respond to the complaints of what we were hearing, or at least sending a letter to the county commission explaining their concerns and their issue with the issues that we've been, I guess, addressed with, and how we can work together as a team to address these issues. But if they're going to purchase it, then I can understand why they haven't intervened in terms of trying to solve some of these issues. And that's just me, just my opinion.
All right, so you're expressing your concerns.
That's right, yeah. I don't want to say that that's the county commission. That's just Chuck's opinion.
Okay, thank you.
Do you want me to address one issue there that came up? And the issue is, if the city of Gainesville does buy the plant, then it's not going to be able to operate the plant without permission from the Florida Department of Environmental Protection. And I suspect what would happen is the current permits would be assigned to the city of Gainesville, just like they have permits for Deerhaven or any of the other utility, and then they would be subject to the same rules. And so I think that we'll be well into wherever we get into with this petition before they're able to negotiate a very complex purchase and sale contract. So, and I think at the end of the day, it's going to take the cooperation of several local governments to try to solve this problem. It's going to have to be a cooperative effort, and it's not going to be solved with some humongous amount of money in the ground already with a shutdown approach. It's going to be a minimize approach.
Mr. Chestnut.
Thank you, Mr. Chair. Have we asked the city of Alachua to, I guess, become a partner in this issue in terms of the administrative hearing complaint? Because it seems like it would help.
Mr. Chair, I'm not aware of that, but I do know the meeting that that Manager Baker referred to that Rick Hedrick attended last week, where they got all of the entities, the city, the county, and then law enforcement, and the city of Alachua. My understanding is they kind of agreed to coordination on the complaint response in terms of who they're going to be referred to. They also, my understanding from his summary is that they all agreed that the county EPD was going to field the dust and odor complaints. The other entities, the law enforcement, would field the noise. But in terms of this issue here that we're talking about, all we've really we've done is we've been trying to get ready, and I guess like Mark said, he did contact GRU, but we haven't heard from any other party. I mean, this has been kind of developing really quick. The one thing I was going to mention about that's kind of related to who owns this, whether it's the city of Gainesville or anybody else, in discussing this with Greg yesterday and really looking at what's in the permit now in terms of permit condition, one thing that's really obvious is that, I mean, the encouraging news is that Greg is indicating that they're doing these things that are going to help. A lot of those things, even though they sound like good deeds, they're not in the permit. So and they're not a permit condition, so that if the management changes of GREC, all these assurances, there's, what happens when there's change of management. I mean, so I do think this permit is a really important vehicle to pin things down, because if there was a change in ownership, the buyer would have to abide by everything that's in the permit. I mean, there's probably some procedural things. But that's the other thing that we need to be paying attention to, is that I think we do have more assurances the more we get locked down in the permit, and instead of just we're going to do this and we're going to do that.
Conclude. Commissioner Pinkerton.
Procedural. Commissioner Hutchinson, did you want to include we said noise, you want to deal with that in a different, but the administrative hearing, want to send a letter to the city of, at least the city of Gainesville, and maybe one to the city of Alachua, just to let them know.
City of Alachua to it, and then also, of course, to GREC.
Just to invite them to be a partner in this administrative hearing. That way, and I can't see really the downside for the city of Gainesville, because they would like this fixed up before they buy it anyway. So.
All right, so there are three parts to the motion on the floor. There's staff recommendation. There's the part to focus on the
fugitive dust.
Right, the fugitive dust, not the 2.5, and then the invitation to the city of Alachua.
And the city of Gainesville.
And the city of Gainesville. Everyone got that? All right. Any other questions from the board before we go to the public? I have two specific questions I need to ask. Mr. Attorney, in response to Commissioner Pinkerson's question about the grandfathering issue, what is the trigger? If we wanted this facility to be under and I'm sorry if you already answered this, I didn't hear it. If we wanted them to be covered by our new noise ordinance, would it be the point at which they begin operations?
I think they'd be covered at the point we adopted the noise ordinance. I don't think they're grandfathered in any way.
So it doesn't
because noise is not a land regulation. It's a regulation of conduct. They're making noise with their plant, and I think that if we change the noise ordinance, it applies prospectively to noise that come out of the plant.
And retroactively.
Yeah, because we don't have land use jurisdiction over the plant. I think it would be prospectively, not retroactively, from the date the noise would be effective.
Right, but I mean, it would apply to any facilities that were doing what they were doing.
Oh, yeah, everybody gets treated the same. So to the extent we have other low-frequency noises that irritate people and we get complaints, if we can develop some system to measure that, then I think that would be applied uniformly in response to the complaints.
Okay, I want to nail this one down. If the source of the complaint, not source of the complaint, the source of the noise that triggers the complaint is inside a non-participating municipality, can we enforce it?
If we can hear it out in the unincorporated area, we have a provision in our ordinance. The problem with that is that even though right now under the ordinance we can hear it, but it doesn't trip the noise meter.
Right.
So it depends on how we write the new ordinance.
But we can go into the city and issue a citation.
Well, there's actually a second problem is we might be able to make our ordinance apply, but we can't make our code enforcement process apply. I think that's what Mr. Wolf may be ready to say.
Mr. Chair, Rick Wolf, Assistant Director with Growth Management. As I said a couple weeks ago when we did the presentation on noise, our current ordinance in Chapter 110 of the Alachua County Code only applies to a noise that's generated that goes into the unincorporated area boundaries. In other words, if the recipient or receptor property was the Public Works Complex in Hague, that would be unincorporated area. We could go enforce our county noise ordinance there. If it went and the noise was measured and it was at a receptor property in the city of Alachua, we could not enforce our ordinance. We do not have jurisdiction within the municipalities.
Receptor or the site generating the noise?
The receiver. The site generating the noise, we, under the county's ordinance, if the noise is received in an unincorporated area of the county, we could cite the source, even though it was in the city of Gainesville, if the noise emanated into the county property in violation of our ordinance.
We can cite them. Can we enforce it? It's a question the attorney just raised.
Well, under our current ordinance, it says that we have the ability to issue notice and to prosecute them through our Code Enforcement Board process.
We do, okay.
I think one of the things that, going back to the question you asked before, typically in noise ordinances that I've reviewed, and this goes back quite a ways, if you change the rules, normally there's a special permit or waiver process that takes place giving an entity that's not in compliance a time certain to come into compliance. And that's how most noise ordinances that I've seen in the past have worked. In other words, if GREC was not in compliance with our new noise ordinance, we would probably, I think, be in our best interest to give them a reasonable time to meet those requirements through whatever mitigation would be necessary. That's how the ordinances that I've seen for the most part in the past have worked.
Okay, and then one final question. I agree with the attorney's statement about enforcement always being an extremely low priority for law enforcement. That's the experience I've had for a long, long time of people calling, complaining about noise and tracking it down. They just have other things to do. So if the option exists of the enforcement entity being some other part of the county, I'm interested in exploring that. I think this is an important issue. It kind of gets backburnered a lot, but noise has a lot to do with quality of life and your sanity. You need to be able to be secure from noise inside your own home. You have a right to that. So if we know we're not going to get effective enforcement through law enforcement, then taxpayers pay for enforcement one way or another. So perhaps a more appropriate mechanism might be through some other county department. And it's something I'd like to explore. So I'm interested in doing that as well. My question was the noise ordinance changes that we're contemplating to more fully address base. Is that the only area into which we could expand the enforcement, or are there stipulations of the noise ordinance? We're still measuring volume. We're just trying to get down to a lower part of the sound range, but there's the quality of the noise, as you and others have pointed out, speaks to the plainly audible standard and whether or not it's causing a nuisance. And I know it's much harder to quantitatively define that, as it could be a noise, just a simply decibel measure. But are there other ways to write into the noise ordinance, other means for protecting the public from fugitive sound other than just volume?
Mr. Chair, the two principal ways in past ordinances have been typically through decibel level readings that simulate the hearing of the human ear, that dBA scale, or by the plainly audible standard. There has been attempts in newer versions of ordinances to look at octave band or frequency delineation to determine for certain low frequencies or bass noise, where you're getting almost more vibration with the longer, lower sound waves than you are getting decibel levels. So there's been attempts at that. Whether or not that's something that's going to be very common to use is I think still, the jury is still out. If I might, on your question of who's the responsible entity.
Before you go there, let me stop you because I don't want to forget this example. I'll give you an example. 10 years ago, probably, someone called me, and I went out to the house to listen to this, and it was from an industrial property nearby. And the noise was a kind of metallic, grinding, oscillating up and down, high frequency sound. It was just fingernails on the chalkboard kind of sound, but it wasn't louder than the standard. It's that kind of thing that just the volume doesn't necessarily cover. And I know that's inherently subjective, some of it. But did I understand, should I interpret your response you just gave, is that we can go into more subjective measures?
Where that analysis is used most is to try to isolate what's the true cause of the noise so that you can do some mitigation or attenuation or engineering design to try to eliminate it muffle it.
Which implies that we can bring that kind of noise under the enforcement of the noise ordinance.
But are you using it as a regulation tool or as a corrective tool to try
well, in this case, the site generating the noise just did not care.
Your noise ordinance can get as detailed and as specific as you want, but you have to have the resources and the machinery and the capability to enforce it. So, I mean, that's... but when you talk about should this be done by law enforcement or code enforcement, back in 2001, I did a paper with a committee that talked about, and we talked with the American Association of Code Enforcement, with various law enforcement entities throughout the country and and throughout the state of Florida. There was very few code enforcement departments in the country that enforce noise. It has been mostly left up by a large majority to law enforcement, and some law enforcement or peace officers that carry law enforcement badges have the capability of doing very specific, very detailed noise enforcement actions. It's just what's the priority and what are the resources and funding to make that priority. Back in 1994, we asked for 4 noise meters to help the sheriff's office after we wrote the ordinance, and we provided training to do that. It's become less of a priority today than it was back in that time. So it's a matter, but I also think that noise happens on a 24-hour-a-day basis, and code enforcement typically works on an 8 to 5 basis. Most of the noises and noise problems that you get are after hours.
Right. And I'm still not sure, I don't have an answer to this question. Let me try again. Are you telling us that we could adopt a noise ordinance that uses some standards for violation other than just volume through the plainly audible standard?
There have been ordinances that have attempted to do frequency analysis. A lot of these have been related more to boombox and bass noises because the plainly audible standard, a lot of the ordinances have said, well, you need to have it in line of sight. In other words, that car has that boombox that's loud, and I know because I can see the car. But if the car's around the block, I don't know if that's the car or the next one. So the plainly audible standards have often been in plain sight or in direct line of sight. But there can be frequency analysis that does pinpoint the source of the noise.
The source of the noise, sure. What I'm getting at is, I'll come back to the example I just gave you. There's a very high-pitched, whiny, metallic grinding sound, which most people would find incredibly offensive, but it's not louder than the standards established in a noise ordinance. Could a noise ordinance be tailored to address that?
The difficulty you're going to have, yes, it perhaps could, but whether it would be enforceable is another question. For example, if you say a certain sound level, a certain frequency, you're going to outlaw based on, it's annoying to me, then you have an air conditioner as opposed to a plant that's making that same frequency, and so that's in violation too.
Issues with the enforcement then, and you have to quantify it if you want any hope of good
And
enforcement.
it becomes a very pure science, I mean, very specific to do that.
Okay, all right. Thank you. Commissioner Hutchinson.
I've been reading a lot about these noise ordinances, and it occurs to me that one of the slopes we need to be careful about making too slippery is all those other things that are out there. We have racetracks, shooting ranges, airplanes and helicopters, concerts, athletic events, explosions at the Florida Rock Cement plant, all of the above.
Chickens and cows.
You got it. And so whatever we do, we have to, we need to be careful how we come up with our waivers and exemptions for these things, because we know that most people, when they hear an airplane going over, it can be fairly annoying, but they know in a minute or so it's going to be gone. And same thing with, I'm 8 miles away from the drag strip, and yet I can clearly hear those cars going. And but again, it's one of those things, 1 weekend a year. So we need to be very careful when we move down this road of a noise ordinance that we don't cast a much wider net than we're intending.
Okay, if there's no more comment from the question, we're going to open it up to the public. Again, we have a three-part motion that addresses the issue of the administrative hearing petition. We have 2 microphones. You can come to either one. Good afternoon.
Mr. Chair, Jim Conish, I believe there's a slight problem with the motion in that it is to challenge the air construction permit. If I heard it correctly, I believe we're challenging the proposed modification to the permit. That's a big difference. I don't want to make a defective motion that'll invalidate your action. Nowhere have we heard what the modifications to the permit are that they're proposing, and at the end of my time, I would like to just know what it is that are they exactly doing that requires them to modify their air construction permit. It's very common for people to request a formal hearing but never go to a formal hearing. Most of these things are settled. If you do challenge it and ask for the formal hearing, which I'm sure the very competent county attorney will do, you're basically going to allege there's a disputed issue of fact, which I'm sure there will be, and you'll basically be at the table. Unlike an intervener who comes along and is just sort of watching on the sideline. You would be a party along with GREC and DEP. Other people are going to be coming in too, I'm sure, the residents of Turkey Creek will be. Then you'll all be at the table. You'll be copied with everything. There will be negotiations, I'm sure. And I doubt very seriously if a DOA hearing officer will come to Alachua County for a very expensive hearing. I do believe this will be resolved like 98% of all petitions for formal hearing, short of the actual hearing, recommended order from DOA, up to Tallahassee at DEP. I don't see that happening here. So I think it's a very good idea to do this. You must be aware that they've changed the Administrative Procedure Act. You will have the burden of proof. Their application will be taken as a prima facie case, and the burden of proof will be on you instead of the applicant, thanks to our Republican legislature, constantly retooling the APA to make it easier for polluters and everyone else to do whatever they want. So that's why we need the $80,000 consultant, because we will have the burden of proof. The applicant will say, here's the permit application, that's our case, and you're going to have to tear it down. And you're going to need experts to do that. Again, where we can go through all these dances, the real critical tripwire is when GRU declares the plant commercially viable, whatever that is, GRU ratepayers will be shelling out $5.5 million a month to GREC, whether the plant produces energy or not. And that's why we can do all this other stuff, but we have to be working with the City Commission on all levels, not just through legal channels, to make them realize that this is a catastrophe, and we have to minimize the overall catastrophe, not just the noise, not just the future dust, but the financial fallout for the community, which is going to be profound. And the City Commission rakes off $41 million a year from GRU, collects $21 million in ad valorem taxation. The general manager sits on the dais, unelected, sets millages for fuel adjustment arbitrarily, spin the wheel approach to it, hundreds of millions of dollars. So we have to recognize that reality, and the county commission has to take a position on the all the implications of this plant, not just the noise, not just the dust, not just this permit, not just that permit. The city buys the plant, you're suing the city of Gainesville. Period. Period. And they have a conflict of interest because they are financially addicted to GRU revenues, a runaway addiction, a larger percentage of their budget every year, the largest off-the-top take in the country except for Tacoma, Washington, 10% of gross revenues. So we have to recognize this reality, and we have to use all means, not just the very expensive means of challenging one little aspect of this with an $80,000 consultant. I support it. But I'm sure, Mr. Sexton, if we all got together on certain things, no, a purchase is not a good thing at this time because of all the problems, that would be more impactful than what you're doing now. Thanks.
Thank you. Good afternoon.
Good afternoon. Ray Washington. I'm speaking on behalf of myself only. My personal involvement as a resident has been totally about the finances of this issue, and I'm not going to speak about those now. I'm going to speak about things that I haven't taken a personal position in. I have represented citizens in legal actions on some of these issues, and I just want to summarize each of those because you're sort of you are effectively dealing with each of those. They're all inextricably intertwined. I like what you've done. I like the motion. I support it as stated. Starting with smell. I agree that that's something you're not going to be able to deal with right now in this proceeding, but it is tied to the rest of this of the problems that are going on there. The smell has been linked to dampness of the wood. This wood was stored at Wood Resource Recovery for many months. The Gainesville Sun had a story in February of 2013 about hundreds of thousands of pounds of wood that was already in storage there. Subsequently, there was a fire there that spontaneously combusted in some other wood, not this wood. So this is old wood, and it may work its way out. I hope it does. But the other problem, which is tied to this, is that when the wood is wet, it gives off more particulates. And the 3,000% exceeding of the 2.5 particulate matter that has already been suggested by Greg that this plant will put forward is going to be increased by water. That's the studies all show that. Wet wood, old wood, dirty wood, it increases the amount of this very dangerous particulate. But I do agree that this may not be the forum to go forward with that. I would just ask if Mr. Wagner would be willing to do this to make sure that nothing is waived by going forward. I looked at the backup and I did see that there is some request for something to do with best available control technology. And I don't know whether that goes to the particulate matter or not. I do know, I didn't participate in the original hearing on the permit. I did file the appeal for clients of the granting of that original air construction permit. So I do know a little bit about it. And the argument from GREC was that we're not required to follow best available control technology because the EPA's rule has not been adopted by the Florida DEP. Most other states it has. Those other states would have rejected this. And so that is an issue. And I just asked that maybe to be sure that it isn't being passed over, that something isn't being left on the table, assuming that it isn't, to the main issue that you're addressing here, which is the dust. I think GREC can get that handled, but as Mr. Bird says, you can't take that chance. You need to file and have that protected. In the best of all worlds, they'll fix it. You won't have to spend the money, and everybody will be happy. But I think you do need to do that to protect the community. One of the problems with that dust is GREC built the plant where they did. They got lower marks for environment than the competing company, which was Covanta, the New York Stock Exchange company. They were going to build it to the southeast. They got higher marks for the environment. They got higher marks for emissions. They got lower marks for finances, which is really a hoot because GREC is now charging twice as much as they bid, but that's another story. Then finally on the noise issue, and I know the light's going to hit me in a moment, I think you're going on the right track with the noise issue, but there is a very important thing to note. The City of Gainesville's ordinance has another prong, which is whether individuals like these folks from Turkey Creek are reasonable people, whether they have extra sensitivity, and if they don't, if they find it to be a disturbance as described in the noise ordinance, it's a violation. Now that opens the doors to, and I only need a few seconds after my light goes off to explain this, that opens the door to an accusation, if you use that standard, that you're being arbitrary and capricious. But I will submit to you that if that standard were put in the county noise ordinance and these folks who have filed hundreds and hundreds and by then maybe thousands of complaints, who out there is going to come to you and say, hey, we've filed thousands of complaints, you're being arbitrary and capricious by not acting? It's not going to happen. So I think that standard might actually work to help these folks, and I hope that you consider it. Thank you.
Thank you. Mr. Attorney, did you understand the question that was posed about leaving things on the table? I'm not sure that I did, but do you want to respond to that?
Right. I understand the question, and I want to go back to what I said earlier. We can only challenge what we have evidence to prove, and this is an amendment to, it's a notice of intent to amend the air construction permit. So to the extent we can produce expert testimony to address the best management plan for fugitive dust, that's fine. And I agree with what Mr. Konish said, that we're going to end up at the table, hopefully, with the view towards making modifications to the operation to minimize the emissions and adverse impact as it relates to dust. So I think that's going to open up possibly some modifications, physical modifications to the facility. So it's good that we get involved now. It's probably better now as it relates to that issue than later.
And the language of the motion, which I guess you had a hand in writing, is okay in terms of not needing to emphasize in the motion that we're talking about changes to operating permit. The language of the motion is acceptable.
Right. It's regarding the intent to issue an amendment to the air construction permit. So
That's all we
that's
need to
correct.
say.
Right.
Okay. Thank you. Good afternoon.
Good afternoon, Mr. Chairman. Nathan Scupp, appearing on my own behalf. If I could please have the overhead. And rotate, if we could. Okay. Thank you, Mr. Chairman. Just want to start by saying I'm in support of the motion, commend the Commission on item 1. I do have a concern that I will express in a moment, but want to commend the Commission for bringing forth the motion. Also, Mr. Byrd, I think that his analysis is spot on in terms of the necessity, if you will, of the county taking action to enforce its interests and the interests of your constituents in requesting a formal hearing to challenge the issuance of the air permit. If we look at Section 4 of what is the Hessler report, one of the items on the motion is to focus primarily on the fugitive dust, and that's commendable, but one of the other issues is perhaps we also need to take a strong look at the emissions. Section 4 of the Hessler report states that a recommended option for the noise mitigation would be to install acoustic baffles. And basically they state, the consultant states, quote, this approach appears to be the only technically feasible option since it would add only a minimal amount of additional pressure drop to the system and would not interfere significantly with the gas flow velocity at the stack exit, an important factor with regard to air admissions and dispersion. So this fix is the only technically feasible option. If it does not work, what's the backup plan? And emissions are implicated by virtue of the consultant's own words. So in addition to fugitive dust, I do think we need to be concerned about emissions and dispersion. So I would ask the commission to consider that. I know obviously we want to minimize costs, but you only get one bite at the apple. But this is important. It's important to make your views known. Important to hold correct to the requirements of environmental air permit that is being basically rubber stamped, for lack of a better term, unless anyone challenges it, which again commend the commission on doing. So just wanted to bring the Hessler report to your attention. Commissioner Chestnut also raised a concern, which was item 3 in the motion on the table, as to extending an invitation to the city of Alachua and Gainesville, and the question arose, why isn't Gainesville doing more? And I want to just briefly speak to that. We could have the overhead, Mr. Chair, and specifically towards the bottom. This is the editorial in today's Gainesville Sun. Very well written, long overdue editorial. But basically, and I'll read the bottom. Stating, quote, while Hunsinger can be faulted for his actions as general manager, the commission is ultimately responsible for utility oversight. As the commissioners move ahead with decisions involving GRU and its leadership, they need to do a better job than he did in terms of acting in the community's best interest. And so we find ourselves in a tension. I commend the county for wanting to invite them to participate in this, but there seems to be inherent conflict because they're of the mistaken impression that they're best buds with Greg. So they're not thinking very rationally over there. So I hope they would join in opposing the air permit, but that puts them in a very awkward situation where they actually may switch sides and actually be adverse to your position and join with GREC and DEP in asking that the air permit be rubber stamped. Now, I hope that they wouldn't do that, but again, reasonable minds don't seem to be prevailing across the street. So I think Commissioner Chestnut's point was extremely well taken. Commend, again, Mr. Byrd, Mr. Wagner's very conservative analysis. But in addition to fugitive dust, again, emissions are being implicated by virtue of the issues associated with the stack. And if you can't fix the noise in the stack, then that leads to the issue regarding what is the degradation to plant performance, as well as emissions and dispersion issues, which are all encompassed within the air permit. Thank you, Mr. Chairman.
Okay. Thank you for your comments. Welcome. That's you. You're welcome.
Commissioner, I'm Russ Paisano. Pardon me. I'm tired out. Another sleepless night in Turkey Creek. Regarding the sound ordinance, I'm one of over 1,200 homes in the immediate area out there that are victims of this situation. It's real. We don't need a sound meter to tell us it's keeping us awake at night coming into my home. I have to sleep in the living room. I wish I knew when they were going to run the thing. Then at least I would go to sleep in the living room rather than having to get up at 2 o'clock in the morning to move, And we've asked for that time and they won't give it to us because I think they're afraid we'd run our own tests and could prove them at fault for a lot of different reasons. Now it's affecting not only our health, it's going to affect our home values, okay? Because under the disclosure in real estate, everybody knows about that. It's already hit out there that homes are for sale. People are literally getting out of their cars if it's running, So realtors have to figure out when it's running and don't go out there when it's running. But under the disclosure thing, you have to, if they hear it or you know about it, you're supposed to disclose it. And it's affecting now our property values, which is going to flow down to our tax values, which affects the school and on all kind of things. These are unintended consequences of this biomass plant that GREC had never built before. It hasn't been engineered. It's been engineered cheaply. It was placed cheaply to save money, like was just mentioned. Because of not having to build roads, they put it close to the road. And it could have been placed somewhere else. But everything out there has been done, in my opinion, on the cheap. Last night, Turkey Creek residents had the opportunity to meet with a gentleman from GREC. His name is Mark, and he's I think he was a PR guy, and he listened to our questions, and he's actually staying in Turkey Creek during his time, so hopefully he'll get to hear it. It was weird last night. I was awake they finally turned the plant off somewhere, or either that or I just lost consciousness and didn't realize it about 4 o'clock in the morning. So it's a real problem, and I don't fault biomass, or I'm not, I just want a nice, quiet place to live, and, we can sell our homes for what they're worth. I have grandkids living next door to me in a unit. That was our dream, to have our kids close to us, okay? And now my granddaughter's having respiratory problems. We don't know if it's from this or not. We're spending a lot of money trying to find out what the problem is coming from. So it's health, it's restlessness, it's sleeplessness, it's real. The sound ordinance, I don't know what the answer to that is, but when over 1,200 people are affected and they're all saying the same thing, that's, what's the word? Plausible?
Plainly audible.
Plainly audible. I mean, that should be plainly audible to somebody and should be cause for action. Thank you for your time.
Thanks for being with us. Afternoon.
Debbie Martinez. First of all, I want to thank you so much for the motion, and I support the motion and your staff and their expertise about this is the area in which you can really be successful in. But when you're talking about the noise, how you need to readdress, upgrade, whatever the legal term is for your noise ordinance, it appears the easiest way to do is just copy the City of Gainesville's noise ordinance, because it doesn't have to be read by a meter. You can use a plainly audible. Once it's determined the person doesn't have schizophrenia, that they're a reasonable person, they're not hypersensitive, they don't have hearing problems, and it has been, the Gainesville Police Department, Lieutenant Ferrara has already reported that it is plainly audible, it is annoying, and it is a nuisance. So it has been done before. In fact, in Stephen Foster neighborhood, there was an industrial business there that was, it didn't have a meter reading, it didn't meet that 60 decibels, but it was plainly audible, and the industrial business had an opportunity to reduce their noise, and either they chose not to or they didn't, so they shut down. So it's not a matter of you to decide or worry about whether or not it gets shut down or not. If the person making the noise does not or doesn't want to fix the problem, that should not be your problem. It should just be enforced. Now, whether or not this jurisdictional argument really holds water, I don't know. So we know that the gun's being shot on the City of Gainesville property in their city limits from that GREC biomass plant, but it's being heard outside the city limits, so it appears that that's the jurisdictional argument, so therefore it's not going to be enforced. So it just seems like everyone should have a noise ordinance to reflect just like the one of the City of Gainesville, and then it can be enforced that it's plainly audible. Or you can do something, another little alternative as well, is a nuisance ordinance. Then that's just based on the person's nervous system, and they just have the petitions, and then that'll solve it as well. But I do support it, and I really thank you all for looking out for the citizens.
Okay, thank you. Welcome.
Earl Save. Good afternoon. Most of the stuff that we're talking about here is available on Facebook. Stop Polluting Alachua County on Facebook. I wanted to back up Debbie's comment about nuisance ordinance to replace noise ordinance. Noise has to do with First Amendment rights and stuff. We want to obviate that problem. We want to respond to people who are petitioning the government for relief of a nuisance. Better done probably through codes, not the GPD or the sheriff. When you have that kind of a nuisance that's being presented as it is in the GREC factory, you have a more concerted way to determine that it's a nuisance by petition of those who are affected. No device can replicate the human ear or the human nervous system. So we forget about the meters. that don't attach to your ear, we forget about that. We go straight to the source, the complaint. And the complaint, if the codes determines that this complaint is valid, then it's actionable. That's one idea to add to or replace your concern with noise with the real problem, the nuisance. I had a chance to listen to Mark Rogers last night, EMI, and he made some interesting comments that any of the people who are looking at rates for at rating GRU might want to close their ears. Now, he said that the biomass plant has to remain online because GRU is currently having problems generating enough power. So that was the excuse that was used to keep the biomass plant running even before they put the sound equipment in there to baffle the objectionable, unsustainable noise. So they intend to run this plant. They intend to run this plant regardless of all the complaints that have been lodged, because GRU is apparently having a problem generating enough power, just coincidentally. Just coincidentally. So Mr. Rogers was informative. This video is online with footnotes. Stop Polluting Alachua County on Facebook. Look at it and see for yourself where this is going. Thank you.
Okay. Thank you for your comments. Good afternoon.
Good afternoon, Commissioners. My name is Paula Stamer. I was also at the meeting at Turkey Creek where Mark Rogers from GREC spoke. He did say that GREC has to continue running because GRU's been experiencing outages. When I asked him more pointedly about that and could he amplify on it, he said he didn't have any examples. He just understood that to be the case. For your information, GRU without GREC has over 600 megawatts of capacity, and during nighttime it usually needs 120, 220 megawatts. During the day, depending upon the weather, it may need up to 350 megawatts. It rarely has to go up to or beyond 450 megawatts in usage. And that total amount of time might be perhaps a few hours annually that it might have excursions above 450 megawatts. So it is not true that GREC has to run because GRU doesn't have the capacity. I did want to comment particularly with regard to the issue that's contained in your motion here. It is my understanding that the petition that, or the announcement that DEP made was not simply to amend the construction air permit. It is to substitute the lower standards of the construction air permit for the final air permit once GREC is operating. And you should be aware that that would thereby delete the requirement for best management plan for things like minimization of fugitive dust, pile management, the wood pile management, and fire prevention, among other things. So this is a very serious point. Now, granted, they have said that they would be adopting the national emissions standards for hazardous air pollutants that were recently issued in January of 2013. But it really has not, to my knowledge, no one has done a real study of reconciling what it was that GREC has committed to do with regard to its final air permit, and how that's going to be possibly compromised. Why does it want to have the construction air permit adopted and put in place, even with some of these additions? And in particular, I have an interest because as an intervener, is this being picked up? I can't hear it. As an intervener on the need petition, and along with several other interveners on other issues in different forums, I was party to a settlement that imposed higher standards on GREC with regard to its emissions as well as other things. And there's no mention of the terms from that settlement agreement. The document itself, which has all the proposed changes, is very lengthy, but I think it should be of particular concern for all of you as to exactly what it is that is being proposed as being adopted in this final air permit. The standards should not be the lower ones that are available under the construction air permit. There should be the highest standards possible. I also wanted to make a short comment with regard to the noise issues, and it seems to me that the county, on behalf of its constituents, any constituents who live in the county, should be able to take action against the city to compel it to enforce its own noise ordinance, because it's causing a disturbance and ill health as well for many of your residents. Thank you.
Thanks for being with us. Would anyone else like to speak? Welcome.
Good afternoon. Janie Hendricks from Turkey Creek. A couple points from last night's meeting with Mark Rogers. He represents Energy Management, Inc., which is one of 3 owners of the GREC plant. It's EMI is one owner, the second owner is Starwood, and the third owner is Bay Corp, Corporation out of New Hampshire. Another point that we learned last night was that, and this is according to Ron Nelson, who's a resident of Turkey Creek, who had spoken to Karen Heiler of American Renewables. She works at the GREC plant. But according to Karen Heiler, the plant has been running 100% during the day and 70% at night. So it's pretty much operating 24/7 at different levels, but it's running constantly. I support the motion. I think it's a great idea, and I thank you for stepping up and looking out for your citizens. Thank you.
Thank you for your comments. Afternoon.
Good afternoon, everyone. Ernesto Martinez. In view of the fact that GRU has imploded and is directly connected and part of the dysfunctional 7, they too have imploded, in my opinion. You are virtually the last straw. You are the ones that are going to make a difference if a difference is to be made. Can you imagine the feelings of the Turkey Creek residents going to the City Commission to voice their concerns, their issues, their problems, and the City Commission in turn decides to buy this bag of problems? Put yourself in that position. That leaves these poor people in the dark. They have no one to turn to but the Alachua County Commissioners, which is U5. This motion has teeth. It has strength. It has the potential to make a real difference in the future of this community. If you do not pass this, you will not be able to sleep tonight. This GRU fiasco is comparable to the Titanic without a rudder. I mean, you guys really have to continue to hold your posture, your strength, your leadership, and lead us in the right direction. Thank you.
Thanks for joining us. Welcome.
Good afternoon, Frank Nosco, Turkey Creek resident. I'd just like to bring out one. I'm supportive of your motion, and I'd like to point out to Mr. Wagner that, and I sent an email to Susan Baird because I didn't have every, but she sent me one, so I sent her one back with some excerpts from their permits, where when you try to find the word Turkey Creek, it doesn't exist, except for little bitty blurbs. This plant is located 7 miles southeast of Alachua, the city of Alachua. So they've completely skewed the presentation from the very beginning, everybody. And because you remember, when these things are done, and having built, I'm a mechanical contractor, most of the time you folks never see these massive documents. And I asked the young man last night, I said, did you ever read it? And he said, no. They put them out, they're prepared, and in this case it was prepared by ECT, a Gainesville company, Jack Doolittle, and they're going to blame the discrepancies on ECT. Oh, they purposely left this stuff out, but somebody directed them to do that. So I just think when you're presenting your case, if you decide to go through with this motion, you make a little mention that from the very beginning, Greg has skewed the information surrounding the residential areas. And it's really disturbing when you see somebody playing for $300–400 million and playing these games. They could have put this plant over on Waldo Road or something like that by the Biomass, the recycling place, but they put it right next to a residential neighborhood, knowing the laws where they can scoot under these things, they get their permits, and there's nothing we can do about it except for watch the property values go down. Thank you so much, and I approve your motion.
Okay, thanks for joining us. Would anyone else like to speak? Back to the board for action then. All in favor of the motion on the floor, please say aye. Aye. All opposed? That passes unanimously. Thank you all for joining us and for our staff for continuing to work on this. This is the third of the 4 citizen comment periods that we have during each of our meetings. If you're here and you want to talk about something that's not on our agenda, please come forward, introduce yourselves, and tell us what you think. Good evening.
Mr. Mayor, Jim Conish, overhead, please. I'd like to finish on my...
Second time today you've called me the mayor.
Awesome. Oh, I'm sorry. After 18, after... Well, it's actually a slight.
No.
Sorry. Not that, Mr. Brady, just the position. It's only like a $40,000 a year job, so...
Understood.
I just wouldn't want to diminish you. Basically, to finish my presentation, I want to remind you all that on October 23rd, when the now disgraced Mr. Hunzinger was standing here, and he waived that $3.9 million a year ad valorem taxes from the plant, he had the audacity to suggest that it might be a good thing for the Alachua County Commission to adopt a rollback millage and give the $3.9 million back to the taxpayers to soften the blow from the Greg plant. That is the level of arrogance and stupidity that we've been dealing with. I just really want to contemplate that it's not going to help the churches, it's not going to help the school board, it's going to go to non-GRU customers. That's the attitude. I want to also share with you a comment that was made by Mr. Stanton. He told the City Commission that it doesn't matter how problematic the construction of the plant was, the value of the plant is that they have their permit. And that's what we should be willing to pay for. Well, first of all, that is a lie. They have an air construction permit. I talked to Mr. Byrd a few minutes ago. They're attempting to water it down with DEP's full cooperation. That's why you're intervening at great expense. They haven't even applied for their operating permit. What they're trying to do in a construction permit would flow through to the operating permit in a way which would be unassailable, which is very pernicious. I would just ask you to really, if you're not going to do it through Mr. Sexton, why don't you have a joint meeting with the City Commission and really look at the noise, the impacts on your property, the impact on residents outside the city limits, the financial implications of the city buying the plant, or even passing the GREC contract through the fuel adjustment instead of the base rates, and all get together as two bodies as to, what the impacts are. You're everyone's commission. And basically running the county commission further into the ditch is not really, financially, is not really in the city's best interest, but they basically have a runaway, renegade, rogue utility that, quite frankly, could very easily be taken away from them. There is legislation coming down the pipeline that would divest GRU from city control, just like the airport. This is coming. This is real. And it's a result of not only the biomass contract, but things that have gone on for many years. So I would like to see our two governments coordinated, and I would like you to pay attention to what's going on across the street, because it will have profound financial consequences for this body. I mean, we just spent $80,000 for one little aspect of this for a consultant. And one final thing I would like you to ask Mr. Wagner about, and I'm kind of curious. The plan is substantially complete. It's going on the tax rolls. I don't know how this works, but I think at some point the tax rolls get certified in June, and then the tax bills go out in November. At what point would the sale have to occur to divest you of the $3.9 million, which I guess would come in the next fiscal year? So, I mean, if you know, you should pay attention to this because you're spending money. How exactly does that work? Like the date of closing, at what point do they not have to pay out? Because they haven't paid anything for the plan because it hasn't been substantially complete to this point. It's substantially complete. It goes on the tax roll. Are you into them for 1 year's worth?
Think so.
Think so. So you got 1 year's worth of taxes. So that's $3.9 million to work with. Thanks.
Appreciate your comments. Mr. Schwartz, do you have a response?
Mr. Chair, I believe that the properties are appraised as of January 1st. I can go verify that, but that's my understanding.
Okay.
An improvement is not taxable until it's substantially complete. It's substantially complete.
Okay.
So,
thank you, Mr. Conish. Would anyone else like to speak during citizen comment period? Good evening.
Hi, I'm Dave Wilson. I'm the chair of the Swanee St. John's group of the Sierra Club. And I came to Gainesville in September 1972. I went on a Sierra Club canoe trip with J.J. Brazington. Some of you might have known the fella. In October of 1972, I joined Sierra Club in November. So I've been a member for almost 41 years. I'm also a math guy. I taught math at University of Florida for 35 years, and so I always think of things as from a math point of view. I'm here today to talk about the Envision Alachua project. My Swanee St. John's group is very concerned about this project, and we feel that you should take some of the Sierra Club's position into consideration, because I think it's going to be coming forward very soon in the next few months here. And so I'd like to just make a few comments about the property. First of all, Plum Creek is the largest property holder in the United States, about 6.5 million acres, largest private, I guess I should say, property holder in Florida with 500,000 acres, and the largest property owner in Alachua County with about 65,000 acres. The Envision Alachua project has been off the radar in terms of my friends. I bring it up and they have no idea about what it's about. They've never heard of it. It's not just simply not present in their brains. So what I want to do is make a couple quick comments here. Do I just put this here? Okay. So there's a map that I've displayed up here, and let me just go through quickly why Sierra Club has taken a position of concern against this project. And first of all, let's try to keep it simple. The property west of I-75 that you see there, so from I-75 west, it's a karst topography, so it's very sandy. When it rains, the water percolates through. The Envision property is between Noonan's Lake, 301, so Noonan's Lake on the east side, 301 on the west side, Hawthorne Road on the south, and Route 26 to the north. So in this map that I put down here, it's the purple or lavender color that you have there. So they're planning on putting in 10,000 homes. Considering 3 people per home, that's about 30,000 people. I just got my GRU bill today. Speaking of the fellow left about GRU. Our family used 3,000 gallons of water this past month. That's 100 gallons a day. That's 50 gallons per person. I'd say that's very much at the bottom level. Talking to the representatives of Envision, that's their goal. Now, you do a little math here. 30,000 people times 50 gallons a day, you're talking 1.5 million gallons a day. That's the goal. Many of you are familiar with the Adena property. They're asking St. John's for 5.2 million gallons a day. So if they get to 100 gallons a day per person, we're in 3 million gallons a day. And we're talking a substantial portion of what Adena is asking for, which is already on the roadmap. Now, here's my main concern is there's no accident that the development went to the west of I-75 over the last 30 or 40 years. And that's because it's sandy. The property, which is outlined there in purple, is what's called poorly drained pine flatwoods. And it's like, I think the metaphor for this is a bathtub with sand in it. So when it rains, the water percolates down to what's called hard pan. And when it gets down 3 or 4 feet, it stops and fills up. So after the rain, we had 16 inches of rain in July. We've had 6 inches in August and September, a 1/20th of an inch or something in October. So even 2 months after the rain in July, when you drove around the property, which we did, you still saw, looking into the woods, you could still see the water glistening in the woods where the people are going to be building. So I don't see how they can not ditch and drain and fill to put this project in. I guess my time's up. Okay. I have my letter to the Gainesville Sun here, if any of you would like to see it. It was printed in August 30th. There's been almost no reaction in the press about this, though I have had, shall we say, many phone calls. Thank you very much.
Thank you for being with us. Would anyone else like to speak during citizen comment period? Welcome.
Good evening. I'm Mary Helen Wheeler, and I just want to second what David said. There are other groups that are also working with these water issues. I've been working with the Awake Marion group for the last year. I'm also on the board of Santa Fe Lake Dwellers. It's been very active in water issues for a while. I would urge you, if you don't know about the Adena situation and what the Plum Creek is going to require, there's going to be a giant fight over water between those two powerhouses, and the rest of us are going to end up having to take what's left. So I would urge you all to do all the research you can so that when the time comes, the Plum Creek is in front of you asking for whatever it is they're going to ask for, that you're well advised about our water. Thank you.
Thank you for your comments. Good evening.
Good evening, Mr. Chair and fellow commissioners. My name is Lynn Kuyas. I have been writing to y'all for months. I live out in the Oaks of Hague, and I'm directly impacted by this lovely biomass plant. Could I have the overhead, please?
Sure. Sit it down there.
Most of the people know me here from Captain Louis Galley. My late husband, had Captain Louis Galley from 1948 to 1994. And some pictures that most people will identify with. Sorry about that.
I bet.
To learn how to use your overhead. But these are maps going.
You can just sit them there and they'll rotate it for you.
You can do it for me.
They'll rotate it for you.
And there's so much significant historical value to Hague. Oh, there you go. I'm sorry about that.
That it, or is it upside down? There we go. One more time.
That one is from 1850, and the other map on the other side is from 1883. Now that he just got that down. Sorry about that. And thank God for Miss Kathleen Pagan. She conducted with the county, conducted a historic structure survey, and Hague has over 15 structures that were all listed on this historic structure, and thanks to the lovely biomass pipeline, we have lost two of these structures that are being sacrificed. I wish, God knows, I wish policy 6.11.1 was enacted for the Hague Rural Cluster to protect these historic structures from development, but as things would have it, we were all taking it for granted. And until all of a sudden someone comes and shakes your life up, it wakes you up. And what you took for granted, you realize as you get older, the things that you hold precious, you cannot buy. And your air, and your water, and your sanity, and thank God for historic. This is the beautiful Hague Methodist Church out there. It is over 150 years old. This is the beautiful Hague Community Cemetery, and they have a fallen soldier from every war as well as a Native American laid to rest in that cemetery. It is a beautiful and sacred site, and unfortunately on the packet for the upcoming Dollar General, which is completely, doesn't even list either one of these sites that I just mentioned, they list everything across 441, a federal highway. This is the Hague Historic Baptist Church. It's my understanding that Hague was named after Archibald Hague, who was a postmaster. Hague had a sawmill, a grist mill, and a cotton gin. And it has amazing, this is the article from 1977 that basically describes all the historic structures in Hague, but it does have extreme historical value, and I'm begging for you to pass this ordinance and start paying attention. I don't know what the disconnect is between the city of Gainesville and the city of Alachua. It seems to me that we're all in this together because we all are Alachua Countyans. I don't care what political view you have. You have to understand your air. If you could have seen what I just saw driving here tonight with the clouds so low, thank God it's raining, but the pollution, I've submitted several pictures, and I know that y'all have seen them. I was driving down 441 at 7:30 in the morning, and the sun was struggling to come through that haze. And as I came by the thing, you couldn't even see the structure itself. So I went to Hunter Crossing, and when I came back, that's when you could barely see the structure poking out. So I just kind of ask you to please start preserving and protecting from development and encroachment, because to know that they're getting 1 million gallons of our water daily, and I have been begging since 1977 for a fire hydrant for my neighbors and I. And I had a lovely 91-year-old neighbor, Miss Willis, who we just lost at 93 on Easter, and she had a kitchen fire, and all I kept thinking is, thank God she had the wherewithal to put that fire out, because why, if you're paying 30 years worth of property taxes and you're trying to be a good citizen and you love your neighbors, why do you have to come and beg for stop signs that are turning pink? Why do you have to beg for fire hydrants to protect your neighborhood? And I'm just saying that thank God the county, and I'm saying all y'all, have stepped up and said, let's protect our water, let's protect our air, let's protect our citizens, because we all are in this together. And I thank you very much for your time, and thank you again. I know you all get the emails from me, but now you know who I am. I'm just very kind of passionate about what I believe in. I'm really lucky to have a wonderful neighborhood. Thank you very kindly. Have a good evening.
Thank you so much for joining us. Would anyone else like to speak during citizen comment period? Welcome.
Good evening. Whitey Markle, Conservation Chair there for the Suwannee St. John Sierra Club. I want to follow up a little bit more on my colleague, Mr. Wilson's comments. We came out with a 4-point position on the Plum Creek project about a month ago. And Dave started touching on the first one, which is water quality. You have to remember that Alachua Creek is right in the middle of that. And that affects 2 outstanding Florida waterways. That's Alachua Lake and Orange Lake. So all that water drains, as we know, it's not karst, so it drains into those watersheds which go into those lakes. Very important. Here's what's very important about this whole process. You guys took the time as a body back in the 80s to develop this thing called a comprehensive plan. And it was mandated by statute, as you all know. I'm not telling you anything new, but it was a long, involved process, and it involved you guys, the elected government officials, not a bunch of people from a corporation that owns the most property in the United States of America. And they come in and they select the people in the envision process. They didn't invite us. We had to wait until they made some positions, and then we have to react to it. And that's what we're doing now. So that's point one. You have your comprehensive plan in place, and I hope it takes another 5 years for that process to evolve where you amend that plan in the right way. We think that hinterland out there between, Lord knows, Baldwin, Jacksonville, Waldo, all the way back over here, that's the biggest hunk of wilderness left in north central Florida. And it's in your county, and it's very valuable to us in the Sierra Club. Point two, sprawl is one of our biggest planks in our position on the Plum Creek situation. If you put commercial and industrial businesses out Hawthorne Road and up and down 301 along the railroad track, it's going to attract people outside of the urban areas to develop housing and commercial pizza palaces and all that stuff along those corridors, which are now natural areas. That's called urban sprawl. You guys know that. You have a comprehensive plan. It's in place. It's supposed to protect those hinterlands from that sprawl. They talk about good jobs. I can't imagine what they'll be. I cannot imagine. Maybe pizza dough people, maybe bag boys at Publix, but I don't see a lot of high-tech jobs out there. Now, if you were to, and I've heard them say that this is going to be healthy for East Gainesville, if the political will were there, a redevelopment plan would be developed for East Gainesville, this side of Noonan's Lake, not the other side of Noonan's Lake. Those people can't get good jobs going around that lake unless they move out there. So there goes that hinterland, there goes that water quality. Last point that we made was very important. There's a wildlife corridor right there. And the bears and a few panthers actually migrate from the Ocala National Forest all the way to the Okefenokee Swamp. They're going to take a great big portion of that migration area out of that corridor. May not be important to developers, very important to the Sierra Club. So that's my thesis on the Plum Creek at this point. I'll be back. Thank you.
Thank you for your comments. Please, I don't want to shut down the good times, but please, let's not applause or hiss or boo on anyone's comments. We want everyone to feel like they can speak their mind without somebody meeting them in the parking lot after the meeting. So please, let's all be respectful and make sure that people who may not be in the majority view aren't afraid to speak. Would anyone else like to speak during citizen comment? If not, we're going to close out citizen comment period and go back to where we were on the agenda. Mr. Chumley just concluded his presentation.